This is hegelcourses.wordpress.com.
On the Facebook page of hegelcourses.wordpress.com, an opinion was expressed. I do not think there is any connection between property and freedom. That means, I contest the connection between property and freedom, and thus Hegel's placement of property as the first category of abstract right. Though Hegel examines the foundations of modern society, focused on the free individual, which requires him to start with property, it is crucial to recognize the historical context. Freedom as a concept first emerged in Western societies through Roman law, which distinguished individuals as owners from objects, ensuring they could not be considered property. This distinction between free people, that is, owners, and those who could be property, that is, slaves, start speech, end speech, evolved into the modern concept of the universal free individual under natural law. Roman law remains foundational for many legal codes today, such as France's Civil Code and the Netherlands' civil law. Hegel's use of property as an immediate concept of personhood is legitimate, as it captures one of the main foundations of the modern state. However, this does not imply that he believed this category to be the sole and universal principle, or that he agreed with Hobbes and Rousseau's naturalist view that society can be wholly explained through contracts. Contemporary philosophers who question the importance of this concept in a philosophy of law may seek to emphasize moral foundations more directly. They wish to discuss what should be, rather than what is. Emmanuel Levinas serves as an example. Levinas, a French philosopher renowned for his work on ethics and responsibility, approaches property differently than economic or legal theorists. Although he did not write directly about this subject, his philosophy has implications for understanding property within ethical and human contexts. At the core of Levinas's philosophy lies the ethical relationship between oneself and the other. The face-to-face encounter with another person forms the basis of ethical responsibility. This meeting with the other calls for a response from oneself, which Levinas perceives as the essence of ethical behavior. In regard to property, Levinas's work suggests that ownership is secondary to the ethical obligations we bear towards others. Property, akin to any material possession, may be perceived as an extension of oneself, entering the ethical sphere once it affects relations with the other. The ethical inquiry is not about the right to own property, but how ownership and utilization of property influence the well-being and dignity of others. Levinas's critique of identity and his emphasis on ethics primacy over law imply that legal definitions of property and ownership could be challenged by ethical considerations. He highlights a fundamental contradiction between the primordial ethical orientation and the legal order, suggesting that justice, encompassing legal frameworks governing property, imposes limitations on responsibility while presupposing it as a condition of possibility. For Hegel, a social philosophy grounded in personal responsibility as the foundational category would possess a utopian quality belonging to the realm of ethical discourse about what should be, rather than an analysis of reality. However, this does not negate the argument that Hegel may not have fully considered how principles of property and contract could result in injustice by adhering to modern law. Property can equate to theft. Contracts can deprive rights when individuals are not truly free. Human needs might surpass society's rational institutions and practices. The Jewish approach to property, exemplified in the discussions of the Babylonian Talmud, primarily addresses damages or torts, such as abuse of property, liability for damages, and deception in commerce. These issues are also addressed in Hegel's chapter on injustice within his first section on abstract right property, contract, and injustice. Yet one might deem this insufficient in light, e.g., of 19th-century factory workers' historical experiences with poverty. It should be noted that Hegel does incorporate moral principles in his examination of property, evident in his critique of Gustav Hugo, who defended immoral property claims. Here is a summary of Hegel's position with regard to a simple defense of Roman law, without any form of moral critique. Hegel criticizes Gustav Hugo's interpretation of Roman law history, as it rationalizes fundamentally unjust and inhumane laws and regulations, such as executing creditors, enslavement, and the treatment of women and children as property. Hugo justifies these through historical context instead of evaluating them against reasoned standards. In stark contrast, Hegel approaches Roman civil law with an acknowledgement of its impact on contemporary legal systems and addresses the foundations of legal rights amidst social and political transformation. He contends that historical events' turmoil has imbued Roman legal notions with fresh intellectual substance, pertinent to the modern era.